The Supreme Court due to meet tomorrow for a hearing on whether it was lawful for Boris Johnson to advise the Queen to prorogue Parliament from last week until mid-October. The appeal follows an unsuccessful legal challenge against the government in the High Court in London, but a successful legal challenge in Scotland, where the highest court there ruled that prorogation was indeed unlawful. Two seemingly contradictory rulings. We're joined from Westminster by Raphael Hogarth, an associate at the Institute for Government. Raphael, welcome to you. Just in terms of the hearing that begins tomorrow, those people expecting this to be done and dusted within a day are likely to be proved wrong. What's your sense of the timings and the process of deliberation and the ultimate issuing of a ruling? What's the process that we're looking at?
Difficult to know exactly, because to some extent it depends on how much the judges disagree with one another once the lawyers' submissions are over. So they've potentially got a number of questions to decide in this hearing. They've got to decide whether the issue is justiciable in the first place, whether it's something for the courts to rule on. They might have to decide, or they might choose to decide, what the Prime Minister's purpose was in doing this. They also need to decide potentially whether that purpose was unconstitutional. So there's plenty of potential for disagreements between the judges. If there are lots of different views on the bench, then could take several days. If there's a sort of consensus between the judges, then it might be faster. I think what I'd expect to see probably is a decision on whether the prorogation was lawful or not in reasonably short order. I'm sure they'll be under pressure to give it this week, and then a full reasoned judgment citing precedents and so on to follow.
And the reason for urgency, quite simply, that there are those MPs and others who want to see Parliament reinstalled.
Yes, exactly. I mean, if the Supreme Court rules in line with the inner house of the Court of Session in Scotland that the prorogation was unlawful and so effectively null and void, that means that in the eyes of the law, that the prorogation would never have happened, and so you'd expect to see Parliament sitting again in very short order. And obviously there's significant amounts of time pressure on that, given that the reason that MPs want to be sitting, or some MPs want to be sitting, is so that they can scrutinise the government's no-deal preparations along with the government's renegotiation of the withdrawal agreement. And of course, that's supposed to be going on right now.
At the end of the day, we are a constitutional monarchy. Where would that leave the judgment of the Crown in all this?
Well, the way that prorogation works is that the Prime Minister advises the Queen to prorogue Parliament, and then the Queen makes an order doing that. So what the Scottish court said is that the advice was unlawful, and so the prorogation that followed was also unlawful. But I don't think anybody would actually suggest that the Queen, for making that order, is culpable in any way, because the Queen acts on the advice of her ministers and by convention doesn't really exercise her own discretion. But I think that what is significant about the position of the Queen in all this is that if the Supreme Court upholds the finding of the Scottish Court of Session that Boris Johnson's true reasons for advising prorogation were not the reasons that he gave to the rest of us, which is to say his true reason was about Brexit, while he told the rest of us that his true reasons were about a Queen's speech and a domestic legislative agenda, then the implication of that is that the reasons that the Prime Minister gave to the Queen were not his true reasons either. And given that the Queen acts on the advice of her ministers, it's obviously extremely important that she can trust the advice that she's getting, and that advice is representative of the Prime Minister's true intentions and completely true.
Parliament has already ordered the Prime Minister to seek an extension from the European Union. That was obviously the most substantive business that they could concoct in Parliament. What would sitting for a few more weeks potentially achieve in terms of parliamentary business?
Well, I suppose there are a couple of things. The first thing is, obviously, Parliament doesn't just legislate, it also scrutinises. So the government is renegotiating, it's preparing for no deal. If Parliament was sitting, then we'd have ministers up in front of select committees being asked questions about how those processes are going and being held to account for the decisions that they're making. Indeed, if Parliament hadn't been prorogued last week, then the Prime Minister himself was expected to be answering questions about that. The other thing is that although that particular piece of legislation on compelling the Prime Minister to seek an Article 50 extension if Parliament hasn't approved a deal or no deal. Although that's now law, there was various other Brexit-related legislation hanging around in Parliament at the time of prorogation, a fisheries bill, an agriculture bill, that sort of thing. And so if the courts rule that the prorogation was null and void and never happened, then that legislation could continue its passage through the House.
Raphael, before the Supreme Court, am I right in saying, I mean, it's not that old an institution, is it? Before then, it would have been the Law Lords and the House of Lords. I'm right in saying that. That would have been the ultimate arbiter in legal matters. Is that right?
Yes, that's right. So
I only ask it because would that have given a veneer of respectability, retaining a sense in which this was part of parliamentary process, which maybe isn't there now, and allowing critics of judicial activism, particularly in light of the fact you've got some courts saying what the government's done is fine, another one saying it's not, reminding people that there's always an element of subjectivity to legal process. Might it have been better? Might this be a situation where actually we're looking at the Supreme Court, it reminds us of the American version. Had we still had the Law Lords, it would have felt more parliamentary.
Well, I think not just a veneer of respectability, but the full substance of respectability is there with the Supreme Court, just as it would have been with the Law Lords, who, as you say, would have heard the case before the Constitutional Reform Act 2005. Obviously, it is the case that this prorogation challenge is an unprecedented bit of litigation. It feels quite unusual, I think, to us in the UK because of the fact that Parliament is sovereign in the UK Constitution, and so we're not accustomed to seeing litigation that's sort of related to what Parliament does. We're very used to seeing litigation against the government, but this sort of confrontation between the government and Parliament being played out before the courts is very unusual. But ultimately, though, as you say, lawyers disagree about the right answer and can argue about it to their heart's content, the court is deciding a legal question. It's deciding whether the government had the power to do what it purported to do, which was to give that advice to the Queen. And so, although it has political ramifications, ultimately the court isn't deciding a political question, it's deciding a legal question.
Raphael Hogarth is an associate at the Institute for Government. Raphael, appreciate your time. Thanks very much indeed.
Thank you.